The subject of my presentation is represented by liability for defective digital content in the aftermath of regulating the business-to-consumer digital services contract, unilateral termination and adjustment of the business-to-consumer contracts in the perimeter of digital content continuously raises interrogations for legal practitioners. The study approaches the inherent intricacies. In the case of the unilateral adjustment of the contract for the supply of digital content by the seller, of the consumer's right to seek for the judicial termination of the modified contract. Thus, in accordance with the second paragraph of Article 19 of Directive 2019/717, the option for a termination of the contract remains open to the consumer, who is basically entitled to terminate the contract in the hypothesis in which the unilateral alteration of the contractual terms negatively impacts the consumer's access to or use of the digital content, unless such negative impact remains to present minor repercussions. So our analysis insists on the fact that, in the case of minor lack of conformity, the consumer's request for the termination of contract is legally unacceptable. On the other versant, in cases in which the impact of the unilateral modification significantly affects the consumer's rights, the consumer is entitled to terminate the contract in a non-onerous manner within usually 30 days of the time where digital content has been modified. So we argue that the anticipatory renunciation of the consumer through the exercise of this right to termination of contract represent unfair terms, which are the contractual clauses imposing the consumer unilateral adjustment in relating to the supply of digital content. So the further development of the market for digital content, however, may be hindered because of the lack of functioning legal framework to deal with digital content contracts. Active participation in digital markets requires trust and confidence. Also on the side of consumers, so digital consumers will only embrace the digital economy if they can be confident that services are safe and that they are meet their expectations, if they can trust the legitimate interests and rights are respected also online. So the legal protection of consumers of digital content was a central theme during the preparation for the proposal for a consumer rights directive, perceived most often as being the central piece of the legal protection recognized to consumers in online concluded business-to-consumer contracts. The mechanism of the withdrawal right on consumer consent not only sequentially describes one of the stages of the progressive formation of the online B2C agreement, business-to-consumer agreement, but also coagulates other protectionist mechanisms, such as the one represented by the informative formalism. So as you can see on the screen, regarding the status of compliant applications and pending in the screening phase, most of them have been amicably settled by the trader after a referral by the consumer. So obligations incumbent on the professional traders as resulting from the provisions of the second paragraph of Article 19 of Directive 2019/770, the option for the termination of the contract is limited for the consumer, who is basically entitled to terminate the contract in the hypothesis in which the unilateral alteration of the contractual terms negatively impacts the consumer's access to or use of the digital content. So consumers will be able to opt out of objective requirements for conformity only if the deviation from the technical standards of conformity is made known to them explicitly beforehand. Since of the professional's shoulders is placed an autonomous duty of pre-contractual information, especially pertaining to the fact that a particular characteristic of the digital content or digital service was deviating from the objective requirements for conformity as specified in Article 8 of the Directive 2019/770, as long as the consumer expressly agreed to a specific deviation from the objective criteria of conformity of the digital content in the pre-contractual stage, while implementing the mandatory rules aiming at avoiding the consumer's detriment in the field of digital services contracts. So as you can see on the screen, the withdrawal of a party from the procedure was marked by pending discussions of the parties and resolutions notes or even inadmissibility resolution in 37% of the cases. From the perspective of the professional trader's liability, the duty of informing the consumer in the pre-contractual stage is on the segment represented by the formation of business-to-consumer contracts, including the digital version of the business-to-consumer contract formation, is doubled or seconded by the obligation to deliver certain pieces of information at the moment of the concluding of the contract. So let's notice that the latter revolves around the idea that the consumer needs timely information inserted in business contract, which is meant to warn the consumer about the existence of specific rights and obligations, and the importance of which the legislator has assessed as being central, such as those relating to the right of consent withdrawal that may be exercised within 14 days in cases where the professional has not complied with the requirements of information formalism from the moment of the contract formation. So in terms of its intrinsic purposes, we may notice that in the pre-contractual stage, the purpose is primarily intended to enable the consumer to compare the various offers received in order to select the most appropriate one for the consumer's specific needs. Nevertheless, as regards the obligation to provide consumers with certain information at the time of acceptance of the offer or incorporation of mandatory clauses is an expression of the informative formalism in business-to-consumer contracts. Its regulation aims to enable consumers to become aware of their rights and obligations under the business-formed contract, thus ensuring the communicating to consumers of adequate information necessary for the exercise of their rights, particularly on the existence, the limits, and the time frame of the right of withdrawal from the business-to-consumer contract. So the purposes for the situations in which a consumer's right to withdraw the original consent exists do not include specifically the cases in which the order digital content or contracted digital services were customized at the consumer's request. Nevertheless, in practice, the gradients and valencies of the notion of product customization remain difficult to determine for the court of law, which remains sovereign in determining whether or not it They are in the presence of a genuine product customization involving the configuration of aspects that deviate from the standard content of the sale offer. And in these hypotheses, in our opinion, it is important to note that the analysis responsibility of the provision of Article 8 would also apply if the product intended to be installed by the consumer or is installed by the consumer in the digital medium and the correct installation is due to a deficiency in the installation instructions in terms of informational non-conformity. So, as previous scholars have underlined, the non-onerous nature of the withdrawal rights, excluding the costs related to the return of the product, implies that consequently the consumer has no obligation to bear other supplementary costs, except in the case of abnormal return of the product handling those necessary to establish the nature of the characteristics of the delivered product. So in terms of concluding our remarks, typical with the formation of the business to consumer online concluding contracts on digital content and digital services are not characterized by withdrawal rights if the consumer's consent due to the fact that the digital content is usually already accessed at the moment at which the consumer intends to retract the previous content. Nevertheless, in the hypothesis in which the digital content lacks objective or even subjective typical elements of conformity as described in Articles 7 and 8 of Directive 2019/717, the consumer enjoys the right to unilateral termination of contract for non-conformity or alternatively the right to obtain an adjustment of the contractual obligations. So the notion of product conformity designates the manner in which the product sold and delivered to the consumer corresponds to the legitimate expectations of the consumer or to any mandatory provisions of the law on standardization of the manufacturing process or even to contractual specifications, both materially and procedurally, as being related to the identity of the delivered product with the one agreed in the sale purchase contract, to its quality and technical terms and delivered quantity, and even from a functional point of view related to the functions or attributes or other technical characteristics which are then initially agreed. So the legitimate expectations of the consumer regarding the conformity of the product may be incidental, including tacitly, in the case of technical characteristics or qualities of the product which are typical or usually intended. Instead, the atypical qualities or functions of the product may be expressly agreed in the business-to-consumer contract and must be subject of express contractual stipulations so that subsequently their absence in respect of the delivered product justifies the consumer's request to repair the lack of conformity. So comparatively, it should be noted that the warranty of conformity as tangible products and digital products as regulated by Article 8 of Directive 2019/770 operates for 2 years from the date of delivery of the product and cannot be restricted or removed entirely by contractual clauses, even if those contractual provisions have been accepted by the consumer. Thank you so much for your attention.